So the Supreme Court's emergency order, which created a significant battle between Texas and the Biden administration over the border, has now led to a new border decision. However, the Biden administration is now playing dumb with that order. So let's talk about what is happening. Now, really quick before we jump into this video, I want to thank one of the sponsors of this channel, which is My Patriot Supply. Now, a lot of you guys are aware that there's a ton going on right now in our country. There's a lot going on, and a lot of people have the feeling that we're not headed in the right direction and that maybe some things could be spiraling out of control. If you have that feeling and maybe you're a bit uneasy about what's going on, you're not alone. And a lot of Americans across the board are taking a ton of steps to help themselves be prepared for whatever might come next. And a lot of people are investing in purchasing and getting emergency food supplies. And if that's you and you're interested in getting some emergency food, I would recommend checking out My Patriot Supply. I will have them linked down below in the details section and also in the pinned comment. You can get 3-month emergency kits and other kits, and they're packed with a bunch of different options, a bunch of different food supply options, and a variety of calories. They have like 2,000 calories a day, and then those will last up to 25 years. So again, if you're interested, you can go to preparewitharmscholar.com to get that emergency kit, or you can click the links down below that will be in the detail section and the pinned comment. As I mentioned in the intro, in this video, we need to talk about a huge decision that just came out, which upholds the state of Texas' right to self-defense and their right to refuse federal government access to certain areas along the border and essentially prevent Border Patrol and federal agencies from cutting border wire. However, despite this order, the Biden administration is now playing dumb and claiming that they can still cut wire despite what that order said. This is an issue that the Supreme Court recently got involved in on an emergency basis. After that, the Biden administration tried to take the opportunity to have the Fifth Circuit rule essentially in their favor and throw the entire case out. However, we received a final decision from the Fifth Circuit, and in the decision, the court blocked the federal government from cutting C-wire along the border, and they essentially upheld the state of Texas' right of self-defense and their right to refuse entry to the federal government. However, like I mentioned, the Biden administration just submitted a notice to the Fifth Circuit claiming that their decision and their order is unclear, and now the Biden administration believes that they still have the right and authority to cut some concertina wire, some C-wire in specific situations based on medical emergencies. Essentially, this position that the Biden administration is taking would moot the entire order because they want to still engage in the conduct that started this entire lawsuit. Now, this case involves a recent Supreme Court 5-4 order, which overruled a temporary preliminary injunction that was granted by the Fifth Circuit 3-judge panel. The Fifth Circuit panel's decision prevented the United States Border Patrol from cutting, destroying, or otherwise interfering with C-wire that the state of Texas had put along 29 miles of municipal and private land in the Eagle Pass area. In this case, Texas originally sued the federal government in a Texas federal district court, alleging trespass and violations of the Administrative Procedures Act, also known as the APA. Originally in the lower court case, Texas obtained a temporary restraining order, which barred the federal government from interfering with the C-wire in specific areas. Texas later sought a preliminary injunction for the same purpose, but the district court denied that request. What was interesting about the lower court's denial was the fact that the judge agreed with the state of Texas on multiple issues, including the fact that the federal government cutting the wire was generally not necessary to prevent medical emergencies. The court rejected the notion that medical emergencies could justify the destruction of the fence and then leaving it open for thousands of people to go through that area just for one medical emergency. Despite all of that, the judge still ruled in favor of the federal government and ruled against the state of Texas. Texas then quickly appealed up to the Fifth Circuit, and also along with that appeal, they asked for a temporary injunction, essentially an administrative injunction, to bar the federal government from cutting wire in these specific areas. The Fifth Circuit ultimately granted the administrative relief in favor of the state of Texas, which again barred temporarily the federal government from cutting wire. Now, in response to that administrative relief that was granted by the Fifth Circuit, the Biden administration then went to the Supreme Court on an emergency application. They wanted to be able to cut wire in that area, and so they asked the Supreme Court to step in on an emergency basis. And on review, the Supreme Court issued a 5-4 order, which granted the federal government's request to vacate that administrative relief and allowed them access to those areas to cut the wire. But you had Amy Coney Barrett and Chief Justice Roberts who jumped the line and sided with the liberals in favor of the federal government. After that Supreme Court 5-4 order, this was back in the hands of the Fifth Circuit Court of Appeals, and the Fifth Circuit Court of Appeals responded by sending the case back down to the lower court to the district court for development of new information and new evidence on this issue. The Fifth Circuit sent this case back down for 60 days, and the lower court developed that additional evidence and facts, sent it back to the Fifth Circuit, and the Fifth Circuit has now issued their final decision. In the decision, the Fifth Circuit decided to block the federal government from entering and cutting wire along the Texas border. And in the decision, the court stated that we now rule that Texas is entitled to a preliminary injunction. Specifically, the United States clearly waived sovereign immunity as to Texas state law claims under Section 702 of the APA. That conclusion is supported by a flood of uncontradicted circuit precedent to which the United States has no answer. We also reject the United States' alternate arguments. The injunction is not barred by intergovernmental immunity because Texas is seeking not to regulate Border Patrol, but only to safeguard its own property. Finally, Texas has satisfied its injunction factors. Most importantly, the United States does not even contest that Texas has shown it will likely succeed on its state law trespass claims. Accordingly, we reverse the district court's judgment and grant Texas' request for a preliminary injunction. Based on the district court's supplemental fact findings concerning intervening events in Shelby Park, however, we modify the preliminary injunction as follows. Defendants are enjoined from damaging, destroying, or otherwise interfering with Texas sea wire fence in the vicinity of Eagle Pass, as indicated in the Texas complaint, in instances where defendants have the necessary access to both sides of the Texas sea wire for immigration law enforcement and emergency purposes. However, now the Biden administration has submitted a letter to the Fifth Circuit claiming that the order from the Fifth Circuit is unclear. They claim there is confusion, and the Biden administration believes that they still have the right to cut sea wire at all locations they claim there may be a medical emergency. They claim that they can do that whether or not the federal government has access to both sides of the wire. So essentially, they claim that even if Border Patrol and the federal government has access to both sides of the wire, they can still have the complete discretion to cut the wire if there is a claimed medical emergency. The letter states that the opinion's introduction and conclusion use different language to describe the injunction barring defendants from damaging Texas' concertina wire fence in certain circumstances. In particular, the introduction limits the injunction to circumstances where defendants have necessary access to both sides of Texas' fence for both law enforcement and emergency purposes, while the conclusion omits any reference to emergency purposes. The judgment issued contemporaneously with the opinion mirrors the conclusion's language. As the opinion notes, both the Border Patrol and Texas agree that the sea wire must be cut in the event of medical emergencies or to enforce federal immigration law. Defendants accordingly do not understand the court's language to preclude wire cutting where defendants lack access necessary to respond to an emergency. So what the Biden administration is doing here is they're twisting some of the language here in the order. They are still claiming that they have broad discretion to cut concertina wire, to cut wire in areas, even if they have access to both sides of the border. So if there's a situation that happens, if there is a claimed medical emergency, they claim that they can cut the wire for that medical emergency. And that is despite the fact, the fact that they have access to both areas. If there is a claimed medical emergency, they say that they can cut the wire. Now, this whole case really started and got, drawn up and gained a lot of traction because of the fact that the federal government and the Border Patrol would cut wire in certain areas for claimed medical emergencies and then leave it open, and then thousands of individuals would then flood through those areas. And so essentially the Biden administration is claiming that this order and this whole lawsuit that got spun up does not prevent them from still doing that. So the state of Texas has won a significant legal battle against the horrible Biden administration's immigration policies, but the Biden administration is still playing games, and they claim that they still have the broad authority to cut wire for medical emergencies. We will now see how the Fifth Circuit responds to this. The Fifth Circuit has been put on notice of the Biden administration's intent and their understanding of the order, and so I suspect that we will get some sort of clarification from the Fifth Circuit, and I would assume that they're going to say, no, Biden administration, you cannot do this. If you have access to both sides and you can avoid cutting the wire, you must avoid cutting the wire. You cannot just say that you can cut it just because there is a claimed medical emergency. So we're going to see how this plays out. If I get any more information, I will let you guys know. If you like this video and you would like to support the channel, one of the best ways to do that is to like, comment, and subscribe. All those things help to fuel the algorithm, and it signals to YouTube that you guys see value in these videos and in this type of 2A news. But as always, thank you all for watching. Don't forget to like and subscribe. And never forget, this nation was built by armed scholars, and this nation will be maintained by armed scholars.